Clearly there's an aspect to this which has caused a large amount of concern, in particular the fining process and the size of the fines, and whether or not that these would have been actually appropriate or proportionate, and indeed whether or not some of the ways in which the Commission has been keeping an eye on such companies, firms, keeping tabs, as they would say, over a period of, it seems, an extended lifetime of any of the infringements that occurred. So this has reached the Parliament's ears, has been for some years now a major part of our discussion. We report on it every year for an annual report, and we would like to get more involved in some of the issues, not just on how you deal with infringements, but actually how you incentivize the right procedure through the programs which the Commission has been working on. I think the Commission does a job, as it should be expected to do. But every time the Commission, which is, of course, a European institution, does something, it does it through the idea that it does it with political legitimacy. And the only political legitimacy it can rely upon is the scrutiny of the Parliament, for which all legislation is passed must, of course, go through the committees that is set in place. This is the only area, if you like, body of law which does allow for the Parliament to be excluded and just have a consultation right. I think this has to change. I think we have to push towards a more modern era where Parliament has a far more vigorous role in what constitutes the law. And if you just take fining policy as one example, where we've been pushing for it to be removed from the guidelines and implanted in 2003, I think everybody believes that this would be a good practice, and it's something which Parliament could and should push to make sure happens. Nobody wants to interfere with judicial process, that's clear, but some discussion in terms of the sanctions that are used, the elements of the information that are used, the length of time to which people are exposed to the discussion, which of course puts them at a commercial disadvantage later, the issue of recidivism, which of course is about repeating the offence, how many times this comes into account, and most important of all, where subsidiaries of larger institutions, sometimes separate through the decision-making process, can be exposed to some quite horrendous procedures and sanctions, which they never really thought that they would expect to actually face. And these are issues which we have to resolve, clarify and work through. Parliament is fed up of being ignored on this key issue, and it is rolling its sleeves up on an annual basis. Every 5 years, the whole aspect and the whole apparatus of choosing commissioners who have to be approved by the Parliament. It's a hearing process where they have to confirm that they're going to do things in a certain way. This could be the process, the curtain could drop on the Commission if the Commissioner says in his statement or her statement, no, we will keep it the way it is. And it could be that the Parliament refuses to appoint. That could happen.